Join us live every Tuesday from 4 p.m. to 5 p.m. Eastern Time on GluFM for Minding Your Business with me, Attorney Rishma Eckert, to discuss the law and your business. Email us with your questions at info@mybshow.com. And remember, success comes from minding your business. Welcome everyone to another episode of Minding Your Business. Today we have the all-important topic of copyrights. And I named the episode Know Your Copyrights. Copyrights, like know your rights. I thought it was clever. I'm not a creative, you guys are. So we'll just go with that as my peak of creativity. So know your copyrights, very, very important topic. I've been getting a lot of questions lately about the issue of copyrights, just knowing how are you eligible, what are your rights, how long does it last, especially when it comes to artistic expression with audiovisual expressions, because now people are doing videos and podcasts and making YouTube videos and things like that, or even with musicians, you want to know where you stand in terms of your intellectual property rights. Yeah. So I thought it was very apt, especially since, we have the radio station that I know there's a lot of musicians and artists that listen to your programming as well. I wanted to definitely have a show that's targeted towards just copyrights. So that's what we're going to talk about today. As Lisa mentioned, my name is Rishma Eckert. I'm an attorney at Eckert Law, PLLC. Just a reminder, always, every week I say, go to the SBA.gov site, see if you're eligible for PPP funding, which is the Paycheck Protection Program funding. If you have a small business and you need help, this is a great resource for you to be able to get help for your small business. Also available on that site is the EIDL loan, which is the Economic Injury Disaster Loan. Again, if you need help with your small business, go check your eligibility and see if you're going to be eligible to be able to receive some help for your small business. As Lisa mentioned too, we talked with Stephanie Fortune last week. She was one of our small business spotlight companies. If you want to be eligible to be a small business spotlight company, please go ahead and email us at info@mybshow.com. Tell me a little bit about your business. The point of having the small business spotlight this year is to be able to help companies within our community. We want to be able to spotlight them, showcase them, to hopefully give them some more exposure for their business, to make up for 2020 or any, disadvantages that you might have experienced as a business owner. So please go ahead and email us at info@mybshow.com, and we can talk about maybe setting up a date for you to showcase your business.
Awesome.
My quote of the week for what I consider a creative topic. It's from, and I'm hoping I pronounce this correct, it's Dieter Ullsdorf, and he says, "The desire to create is one of the deepest yearnings of the human soul." And I absolutely love that quote because you see it from the time that you're born. For those of you with children, the first thing they do is they sing. It might not be a song that they know, but they think of something, or they play instruments. They might not know that they're doing a quote unquote musical composition at the time that they're doing it, but they are. It's something that they're creating for themselves. So that desire to be creative is just so inherent in us. Mm-hmm. So adding the business part, the law part to that creativity is that we have to be able to talk about protecting that creative spirit and protecting your rights as a creator. Now, I know that we have talked in the past in some of our shows about the fact that if you're doing a business and you're in the business of making music or you're singing, that you also have to be able to know the business side of having the creative, the creation. You have to not only know how to do the music, or just the painting or whatever the case may be in terms of your creativity, but you also have to know how to go about protecting those rights. Yes. And in other episodes, we talked about making it into a full-fledged business, that this is not just your thing that you do, but this is the thing that you do as your business. And it's the thing that you do that needs to be protected. And it's the thing that you do that makes money for you. So it's great to have that creative spirit and that creative soul and that yearning to be creative. That's great. Put that in one pocket, a bucket somewhere. But we also have to talk about the bucket that's in my wheelhouse, which is the business side of it, and also the intellectual law property side of it.
Which is the side
So
that gets
let's get
overlooked the
into
most.
what's that, Lisa?
That's the part that gets overlooked the most.
Absolutely, because and I know a lot of creative types. You're creative. You just want to put your work out there. You just want to go ahead and do your thing and express your soul and express yourself. That's well and fine and that's great. But at the same time, if you want to translate that into any sort of business or being in the industry, we look at the greatest artists out there. We look at some of the really, really popular singers out there that make their own music. It's not that they sit in their home and they make their music, but they also have to be able to have a record deal, publish their music, do performances, sign agreements, have all this intellectual property rights as well. So it's kind of like two sides of a coin that you need to be able to further your business if that's what you want to do.
Right.
Now, if you want to just make music for the sake of the joy of it, and I know quite a few people who are not interested in really pursuing it as a career, they just like it because it helps them to express themselves or it's cathartic and they just go ahead and make videos and stuff like that. And that's not your main part of your business and you have
Right.
another career, that's fine too. But we're talking today to the people who want to make this into a business, and we have to be able to know how to go ahead and copyright. So I'm going to approach this more as an FAQ, or frequently asked questions, because what I ended up doing is compiling the majority of the questions that I get, and I want to just be able to answer those questions in more of like an FAQ format. And of course, Lisa, if you want to give them the numbers that they can text their questions to, that would help as well, and I can answer them while I'm on the air.
Right. The numbers are 646-742-7324 or 862-215-3979. And if you are watching the live stream, the numbers are being displayed consistently throughout the episode.
Thank you. Thank you. So very basically, let's start with what is a copyright? I'll have creatives or clients come to me and say, hey, I made this video, or I'm doing this web series, or I'm whatever the case may be, and I need to protect it. Not everyone is going to say, hey, I need my copyright protection for this audiovisual work that I'm creating. That's not how I usually get the questions. So I have to make sure that I understand what it is, first of all, that they're trying to protect.
Right.
A copyright is a protection that you have for a creation that you've done, something that you've made, right? So if you've written a song and you've written the lyrics, that's a creation that you've made. If you sing a song and it's your voice and your composition and you do, the entire arrangement of the song, that's a creation that you've made. If you are painting and you're not necessarily duplicating anything, but you're going ahead and painting your own depiction of something, that is a creation. That is something that you have done as an original work. That is what we're talking about here. Copyrights for original work, original works. The creator of that original work is the one who is entitled to the copyright protection. Now, that's generally speaking. You can always assign or transfer those rights to another party, but the person who creates the original work is the one who is entitled to the copyright protection. So the follow-up question I always get for this is, so why is that different from a trademark or a patent, right? So if I have this original thing, can I trademark it? And I get this a lot. I did this video, can I trademark my video? And then I have to explain, like I'm gonna do now, the differences. Trademarks are for marks, a name, a logo, a sound, a color, something that is identifiable as a mark to be protected in association with the business that you have. So for example, the Nike shoes with the swoosh, that's a mark to be trademarked. That's not necessarily a original work or original piece of art that's being created. So you can have that original trademark in that you have created a logo, but if you want to go ahead and protect the actual logo for your company, that's going to be something that's trademarkable rather than copyright.
So if you trademark your name, let's say I'd go and trademark Lisa's Hair Salon, right? In order for me to do business with that name, do I still need to go and register it with the divisions of corporation as a fictitious name or so on and so forth?
Great question. And I'm so glad you brought it up. I didn't even have it in my bullet points to bring up, but now I will talk about it. When we're talking about intellectual property protection, that is very different and apart from registering a company. So think about it this way, and this is going to be specific to Florida. If you're registering a company, we all know about sunbiz.org. That is the Florida Division of Corporations website. That is where you would go to tell the state of Florida that you now have this business or this fictitious name, as you mentioned, or you're operating as a business. So after you're done with that and you're operating as a business, or at the same time that you're operating it as a business, you may choose to also have intellectual property rights for that business. So one doesn't preclude the other at all. So if you have trademark Lisa's,
Hair salon.
Lisa's salon or whatever it is, that might be too generic to trademark, but we can maybe have another episode about trademark.
Right.
That might be too generic to trademark. But let's say, Lisa's whatever, and we decided to trademark that specific character. That doesn't mean that you are now protected in the state of Florida as a business.
Okay.
Someone else can go on the Division of Corporations and Florida's in sunbiz.org, see that Lisa's salon is not taken, and actually name their company that.
So then, what type of legal hot water would that person who went on Division of Corporations to register that name, even though someone else already has it trademarked, what type of legal hot water would that person be, and if any at all?
They can technically. That's a very interesting question, because now they would have to show how they're not necessarily infringing on that trademark to be able to pursue. They may have to change the name of their business because trademarks are federal and copyrights are federal, and this is state. Okay. So remember too, and I want to make this a point because I've had this come up last week twice. The sunbiz.org, and I'm speaking specifically now for Florida. I don't know how it is in the other states. But you have clerks that are working in the background to process all that paperwork. They are not looking for the validity of, for example, does it infringe on an existing trademark? They're not doing that research. They are putting in what you put on your questionnaire, and they're putting that into the system, they're processing fees, and that is the job that they're doing, right? So I've had 2 questions last week from 2 clients saying, well, wouldn't the clerk flag me, blah, blah, blah. And I said, look, these clerks are not attorneys. They're not doing the legal research in the background to make sure that you're doing this right. They're transposing what you've put on your questionnaire into the system. And I think it was a matter of what came up with my client was a matter of putting the wrong title for the name. So the person was like, John Smith, and he put something as a title that wasn't supposed to be there. It's supposed to be another title. And he thought that the clerk would correct that. And I told him, no, the clerk is processing your questionnaires and your payments. They are not acting as your attorneys. Now, the huge difference, when you do a trademark application and when you do a copyright application, you have examining attorneys that process what you're doing. Every time I do a trademark application and I'm getting what's called an office action, it's a correspondence from the trademark office. It is from an examining attorney. These are people who are going into the background and they are checking to make sure that you are doing everything according to the law. That is the huge difference. So in terms of legal hot water, they may be able to, the person who is registering that company may actually be able to be blocked from using that name because of the federal trademark that already exists, and they may have to change it.
Okay.
So very, very important. 2 different things. And I've also seen this, and I'm sort of being tangential, but I also saw this where someone trademarked, since we started talking about trademarked the name, and then someone else went and bought the URL or the domain name for it.
Oh, yeah.
So if someone went and bought lisasalon.com, and then they call me in a panic. What do I do? What do I do? I said, well, they bought it fair and square. You have to try to now buy that domain from them. You know, you can't block them from something that they bought fair and square. So it's a lot of things to think about. That's why a lot of business attorneys will do business planning sessions with you, and they will say, okay, let me see what you want to do with your business. We have to do this. We have to check that. And you do a planning session, because this is not just a one-off thing. Right? So that's trademarks is for marks. Copyrights are for original works. Patents are for inventions. It's something that you have come up with, some novel thing or a new use for a thing, or an improvement on a thing that you've invented that you can get a patent on. So that is very, very different from having a copyright, right? So because you don't invent the music, you don't invent the lyrics, you create it. So those are the differences with those three.
Okay.
What types of things are usually eligible for copyright protection? Now, if you go on copyright.gov, which is the federal government site for copyrights, you will see, when you click on register a copyright, loads of different categories that you can fit into. You can have literary works, meaning you've written a book, or if you've written a blog or something like that. And there's also a section for digital content. Ads, architecture, artistic works, technical drawings, podcasts. You can also have musical compositions. Now, for the artists out there, musicians out there, musical compositions, we have to talk about copyrights in the sense that you are copywriting per category of what you're doing. So for musical composition, you may have the actual lyrics on one side and then the musical piece on the other side. And then you may have a resultant song. All of those could potentially be different copyright applications, depending on the categories that you choose. So you have to be very, very careful about how you categorize what you're trying to copyright, because you have to fit what it is that you're doing in terms of your creative expression with the category that the Copyright Office is asking you to put. So that's musical compositions. You can copyright software. You see this all the time. Like, I want to copyright this code that I've done. So it's a very different and distinct things. You'll see literary works, artistic expressions, sculptures. My last copyright I did was an actual painting that my client wanted to use and transpose it to handbags and jackets and notebooks. They wanted to use this original painting to be able to use that print to make other things. So I definitely suggested to her that she go ahead and copyright it, because you don't want someone taking that print and using it, and not have any ramifications for doing so.
Right.
What can you not copyright? What can you not copyright? Just by example, facts, ideas, methods of operations, and systems. So there's this big debate, and I get it all the time. Can I copyright a recipe? I want to say no, probably not, because what is really a creation? Is that really your creation, or is it a list? If I tell you 2 pounds of flour and 1 egg, I'm not creating that. I'm putting it together as a list. So there's always that back and forth debate about whether or not a recipe is just a list or is it an original work. I think it's more of a list. A lot of the case law says it's more like a list. So those are the types of things that you can't necessarily copyright. It has to have that original creative element to it. Has to, or else it won't be eligible. And the Copyright Office is very specific about what it is that you have, who's created it, is it an original work? I mean, they are very specific in their applications to make sure that they got it right.
Let's go back to the musical piece that you were talking about earlier. Let's say one person came up with the rhythm, right? Mm-hmm. And then the other person wrote the lyrics. Mm-hmm. But then none of those things would sound good unless the person put their melodious voice on it, right? Mm-hmm. So then who has, like, how would we, each person, protect their contribution to that piece of work?
Very, very good question. The way that the Copyright Office is set up is you have different applications for for lots of different things. There's applications that if you have a single creator, so you do the music, you do the singing, you do the lyrics, you do everything, and it's a one-man show. Then there's applications for multiple contributors, and that is where you would specify who is doing what. And like I said before too, you have different things that you can copyright. So if the person who made the rhythm is the one who wants to copyright that rhythm, and he made it or he or she made it, that's hers to copyright. So that's apart from someone who then uses that rhythm, puts the lyrics and the voice to it, and then publishes it. So the person who puts the song together, meaning the lyrics, the rhythm, the singing, the voice, and all that, when they copyright that final song, they have to make sure that they include the contribution from everyone. And there is space on the application where they ask specifically who does what, or you have to put who does what.
Okay.
And then on the other side too is that person who did the rhythm, I'm pretty sure that they're going to want to look into copyrighting that rhythm to make sure that whoever uses it in the future knows that their rights are protected.
Okay.
It gets a little technical, and I've noticed in the
Yeah.
last couple years that the Copyright Office, and this is the government Copyright Office, has gotten a lot more akin to how the Trademark Office is, where they tend to be very, very technical. And I think that there's a move towards that right now to be, I don't want to say more complicated because I don't like to say that it's more complicated, but they are definitely making more of a move towards how the Trademark Office is. In even like the revamping of their website, the website looks different. There's new updates in the music industry when it comes to copyrights that I definitely will cover. There's 2 new acts that I want to cover before we end the show today, because it just shows that the Copyright Office and the government is trying to keep up with the technology that's coming in right now. So question I get asked, so don't I already have a copyright if I go ahead and just make this music or do this painting? Why do I need to copyright it? Don't I already have it copyrighted? Technically, yes. The copyright protection is affixed to you as a creator at the time of the creation, at the time you do it. So you do the painting, that you already have copyright rights to the painting. If you do the music and lyrics and you record it, you already have copyright protection or copyright rights affixed towards your creation. So it's at the time of creation. That's how the law looks at it. Now, the follow-up question to that is, well, if I already have copyrights, why am I going to go through going to copyright.gov and this whole entire process of trying to figure out how to do the application, pay the fee, and do all this? That is because when you register a copyright, that is your way of being able to enforce the intellectual property rights that you already have. So for example, if you need to go to federal court to sue someone for a copyright infringement, you have to have that copyright registration number on it. So it's more to enforce your rights than anything else. So if you want to sue for damages, if you want to sue for attorney's fees, if you want to sue for any of these things, you have to make sure that you have that copyright registered. Now, what happens if you don't have it registered? You can negotiate. So for example, you can if you want to. So for example, way back when, I had a demand letter from an attorney saying that my client has infringed on his client's intellectual copyright, intellectual property in terms of a copyright of some original design for something or the other. I can't even remember what it was. Now, that attorney did not include the registration number for the design or whatever he's claiming. He did not include registration number, blah, 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 for this design, and now you need to cease and desist, or I'm going to sue you. He never included that. What do you think I did with that letter?
Trash it.
I told my client, he can't sue you unless he has it registered.
Right.
And so they were like, what do we do? I said, continue doing what you're doing. And they're like, okay. And that was the end of that. Never heard back from the attorney again. Why? Either he learned afterwards or he already knows that he's not going to be able to enforce that right unless there's a registration number. Now, in contrast, I got a I got a cease and desist letter from my client saying that my client used certain photographs that were copyright. Registration number this, registration number this, registration number this, and we're going to sue you in federal court. How do you think I reacted to that letter?
Differently.
Very differently. Got on the phone with my client and I said, you guys, we need to figure out a settlement amount right now. They were asking originally, I think it was like up to $150,000, which is what your statutory amount is that you can ask for per infringement, $150,000. We ended up settling for about, I think, $4,000 or $5,000. So, you know, I definitely looked at it in a different way because legitimately that creator of the photographs that my clients allegedly used, though they had rights. He can technically file a federal lawsuit right now because he has it registered. So for all of those who are saying, well, I already have my copyright, I have my poor man's copyright, that's fine. You know, you do have protection, but what's protection without enforcement? If someone is using your intellectual property rights, what are you going to do? You don't have any teeth for the enforcement. And those are two very real, tangible examples of some stuff that I've dealt with in the past for my clients. One was a chuck it in the bucket, and one was a, oh my goodness, we need to settle this case right now because they can very well take you to court for $150,000 statutory damages each infringement. And I think there was about two or three for my client, alleged infringement. So just goes to show, why is it important? So that you can actually really protect and enforce your copyright. How long does the protection last? This is one of my favorite ones because when I tell people, I usually get that jaw drop. If you are an individual, your copyright protection would last your entire lifetime plus 70 years. 70 years. For your lifetime plus 70 years. That is what your copyright protection gives you.
That is awesome.
Mm-hmm. And if you are a musician that's working for a company, for example, and you're doing like a work for hire, meaning that, you know, you're doing this for a company, your copyright protection is 95 years from the first publication or 120 years from the year of its creation, whichever expires first. So that's if you're doing a work for hire for another company.
Okay.
So we're talking about really, really, really long protection times here. And that's where I get the jaw drop. Like, really? I said, yeah, because what does the law want to do? The law wants to make sure that whatever your original creation is, it just remains yours, right? It remains yours unless you decide to assign it or sell it or license it or whatever it is your innate right to keep what you've created. So those are the timelines that we're looking at. So if you're waiting for someone's copyright protection to expire so that you can try to take it, fat chance it's not going to happen. Your best bet is to try to license it if you want to use it.
Question. So we have an artist who they're the singer on a composition, right? But when the package was registered, you know, so they could get their royalties, the producer, instead of using their legal name, they use their stage name.
Okay.
So how does that artist go about collecting their share of the royalties if the name that's registered for them is their stage name and not their legal name?
Yeah, that's a good question. And I think that's more on a technicality of maybe doing like a fictitious name for herself or himself, and having that connection of what that person's full legal name is and what their stage name is. I mean, that can be remedied on the back end. Okay. I don't think that you need to go in and necessarily change all the registrations to include this person's real name if they want to choose to use their stage name. I think it can be remedied on the back end, maybe do like a fictitious name or something like that, that will still entitle you to receive the remedies. So,
Okay.
if my name is Rishma Eckert, but I want to go as Rishma D or something like that, again, I am not creative. People don't laugh at me. Um, but if I wanted to go as that, I'm pretty sure, I could do like a fictitious name filing saying that I'm doing business as this person. It's just like your salon idea,
Okay.
It's a salon doing business as, you know, here.com or whatever, or
Okay.
whatever you want to do. So that could be fixed on the back end, and then you would still be entitled to your royalties and your payment for your services. That's how
Okay.
I look at that, compensation for your services. So what rights do you have once you have a copyright? The rights that you have include you can reproduce your own work, you can create other works based on your original work, you can, sell your work, display your work, you can perform your work, you can do pretty much what you would think of is going to be your rights under having a copyright registration. You can use it the way that you're supposed to use it because it's your creation. What sort of when we talk about copyright infringement, what is it that people are saying? What do you consider copyright infringement? Copyright infringement is basically breaching the rules that I just mentioned of all the things that you're eligible to do as a copyright holder. Now, the infringement, why is there an infringement? Infringement is because either the person who is infringing did not ask permission and have written permission to use the original work, or they didn't pay for it or license it in some sort of way. That is what we're talking about infringement. We're not saying, if you have a license agreement with someone and you are able to use this particular product or this particular song or rhythm or whatever the case may be, you're not infringing if you use it just because it's someone else's original work. You can have the original work, and then you can have, like I said, the transfers, the assignments, the licensing, or even selling. I know quite a few people who write for other companies, not necessarily as employees, but independent contractors. If the company likes their songs, they'll buy it from them. Does that person now can that person who wrote the song or wrote the lyrics go back and say, well, that's a copyright infringement because now Rihanna is singing the song that I wrote? No, because you've sold it. So there must be, if you are not the original person using that original work, then there must be some sort of paper trail, money trail, whatever the case may be, to show that you've assigned those rights.
Question.
Yes.
If you are the original creator of the work, but you didn't register it, you didn't protect it in terms of copyrights, and then
Yes.
someone else used that song. Let's go with song, but you want to sue them for infringement. Can you go like try and get a copyright protection really quickly and do that, or since you're registering it after the person used it, it's not going to really hold up? How does that work?
I tell my clients all the time, you want to go to court, go register it right now. Register it right now and wait. And no, seriously, you'll take about, it takes a while. I'm not going to lie. You're not going to register and get your copyright certificate in a week or two. It takes
Right.
months, sort of like trademarks. But if you have a great case, and we're talking the high end statutory damages is $150,000 per infringement.
Right.
So you can send a cease and desist letter, and I've actually done in the past when I know that my clients have not registered, saying we are in the process of registering, so that this other party is put on notice that a lawsuit is coming if you don't stop.
Yeah, but they're not actively using it. They already used it like 2-3 weeks ago, and it's been here. The event came and went. How are you
Yeah.
going to sue them for that if they're not actively using the?
Well, if the minute that they've used something that is not theirs and claimed it as theirs, that's an infringement, and that's actionable.
Oh, okay. Wow.
It's actionable. Yeah. So, if they're doing a performance, I guarantee that someone has it on recorded somewhere, someone has it on their phone, someone has it as a TV station, whatever the case may be. If you've infringed, that's already an infraction. You've already infringed. And if the original creator chooses, they can go ahead and copyright their original work, and then they can sue them.
Okay, so you can retroactively Okay.
You
Wow.
you certainly can, especially if it's your work. And now, when I do my intakes with my clients, I ask them, so is this really your work? When did you create it? I do my own due diligence because I don't want someone coming to me saying, I created the song and it turns out not to be theirs, and then I'm now lying to the copyright office when I do my application. I don't want to get into that situation.
Right.
But more than likely, if you're going to spend the time and the money to be able to do a copyright application, I don't think that you're going to be doing this to lie to the federal government. So, I do my own sort of questions and due diligence. But yeah, what you just described is a copyright infringement that's actionable.
Okay.
So
Good to
be
know.
careful out there. Be careful. Why do you think that when you browse through YouTube, I had this acquaintance, I won't say a friend, I had this acquaintance who used to always use other people's um, rhythms and makes his own songs and puts it on YouTube. What do
Oh,
you think happened? YouTube came in and took all his videos down because he's not supposed to, unless you have your license to use that person's rhythm. But again, this person wasn't making money off of it. They were doing it like recreationally. It was just a fun thing. This
yeah.
wasn't like he was trying to sell it or whatever. But that's still an infringement. That is still an infringement. Because if you don't, again, listeners, if you did not get the permission from the original creator, if you
Right.
did not buy it from the original creator, if you did not license it from the original creator, you are infringing. And the government takes it pretty seriously.
And YouTube is I mean, I shouldn't say bad, but they've actually gotten so much better in terms of protecting other people's copyrights, you
Yeah.
know.
Yeah. I can imagine YouTube probably has like a warehouse of people working for them, or software that skims. I think that's more accurate because, now we're living in
Techno.
2021. Yeah. We're living in modern times.
Yeah.
I'm sure that they have really great software programs that skim through to find. I remember YouTube now, if you go to, oh, I don't remember what the link is. If you sign into your YouTube account, I had to do this for one of my clients. You sign in, there's a specific area that talks about the licensing and all the things like that are licensed that you have to go through that process with YouTube too to be able to have put them on notice of the licensing for your whatever you put out. So it's already there. YouTube already has agreements with these other licensing companies, and that's why they do it as well, right? They have to
Wow.
protect their clients, so to speak.
Right.
And they've gotten a lot better because I've seen people gotten like their whole channels taken down because it's just infringement, infringement, infringement. So anyway, I'm getting off topic and I only have 10 more minutes. I want to get through my other question I wrote down was, can I use someone else's work? I think I sort of covered this already. You can use work that's in public domain. You can use work that you've licensed. And you can use work that is under certain statutory defenses that fair use. But those are under the copyright statute itself. You would have to look to see what those are. So you can use someone else's work. You just have to make sure that you're under those parameters to be able to do that.
Awesome.
Now, there's another question that I've gotten a couple of times, and it's like, I don't know how they came up with this, but someone told me if I'm only using like 6 seconds of a sample, that's not actionable, right? Like, I'm not gonna get sued. Isn't there a 6-second rule? I don't know, Lisa. Have you ever heard about that?
I have never.
Me neither. So I don't know where my client got this from, but he was convinced that if he only used 6 seconds, that's somehow not an infringement. I promptly told him that first of all, I've never heard about that unless there is a case law somewhere out there that discusses a threshold for infringement. But as long as you're using something that is not yours, you're infringing. So it doesn't matter if you are using 6 seconds and it's identifiably another person's song, they can sue you. And you see that in the music industry all the time.
Oh yeah.
Artists suing other artists because they didn't ask for permission to use their work. In the last, let's see, 10 minutes or so, I want to talk about 2 new updates for musicians. And this is, when I say new, I mean really, really new. The first act, it's two new legislations that came out for musicians. The first one is the Music Modernization Act, the MMA. And this was passed in December 2020. We're talking about, that's how new this is. December 2020. The Music Modernization Act is an act that came out because the law is trying to keep up with licensings especially for digital users, because it gets so hard when you have streaming services. Back in the day, it was so quantifiable because you have the records, you sell the records, people play your record and all that. Now you have all these streaming services, and the law is really trying to catch up in how they're going to be able to do the royalties for streaming services. So they came up with this Music Modernization Act. Look it up, MMA. So it says here, it updates the copyright law to make it statutory licensing fair, or more fair, for creators who are using digital music providers. So basically what that act does is the office has designated what's called a Mechanical Licensing Collective Inc. So the MLC. So the Copyright Office itself is going to have this database or this collective where they're going to be able to collect and distribute the mechanical royalties for musicians.
That's awesome.
And I thought, how interesting, how very interesting. It says here too, and I'm reading off the copyright.gov site because this stuff is so new that I was like, oh wow, I definitely want to make sure I bring it up in the show, but this is all still super new. It says here, the U.S. Copyright Office has designated the Mechanical Licensing Collective Inc. to collect and distribute mechanical royalty payments under the MMA Act. So it says here, as of January 1st, 2021, this is how new this is. January 1st, 2021, songwriters and music publishers must register with that MLA, that licensing collective, using its online claiming portal to receive royalty payments under a license agreement.
I think that's awesome because it seems like it's easier for people to get their songs registered so they could get paid for their work.
I think it's fantastic.
Yes.
When I was going through this for one of my other clients, and again, this is so new. Look it up. If you're an artist out there, look up the MMA. Because you are going to have this portal now, or this hub where you can get paid, and it's run by the government, which is great. So now you're not looking necessarily to do it all by yourself, because that's tough. It's tough to go out there and try to enforce everything by yourself because you don't know what's going on. But if you are making it mandatory to have this hub so everyone can get their fair share, that I think it's fantastic. I honestly do.
So what does that mean? What does that mean for ASCAP and BMI and?
You know, they're still publishing companies. I'm pretty sure that they're still going to have their role there, because a lot of them are enforcement as well, because a lot of my dealings with BMI and ASCAP are them trying to serve cease and desist letters to my clients. So they're really out there as a force to reckon with in terms of protection for their clients. So they're still going to find their role. They're one of those I consider too big to fail companies. I mean, they're out there and they're solidified. But I think this is fantastic in terms of having a hub to make sure that creatives get paid their mechanical license. The other thing really quickly I want to mention is the second new development is called the CASE Act. That's Copyright Alternative in Small Claims Enforcement Act. Copyright Alternative in Small Claims Enforcement Act of 2020. So again, December 2020. So now this is the way that the Copyright Office is going to try to help with small enforcement of certain copyright infringements. So they created what's called a Copyright Claims Board. It's CCB. Now, this is why I think that the Copyright Office is trying to get more in line with the Trademark Office, because the Trademark Office also has their own tribunal that they use to do enforcement cases. So now we have the copyright, they're going to have the Copyright Claims Board. It's a 3-member tribunal within that office that you can file copyright infringement claims involving less than $30,000, which is what they consider small claims. Less than $30,000 is what they consider small claims. So it says here that the office is in the process of developing this CCB, this tribunal, which should be available to hear claims by December 27, 2021. So they're in the process now of putting together this CCB so that if you have small claims infringement, and again, that's under $30,000, if you have a small claim infringement, you can now go to this board instead of filing a federal lawsuit, which is what you would have to do otherwise. Wow. So they're making strides. I think that the Copyright Office is making some really good strides towards helping artists and helping creatives, and I think it's fantastic.
Yeah,
I think it's absolutely fantastic. And notice, small claims for them is less than $30,000.
I know.
I saw your face on that one.
That's a lot of money.
But again, if you're talking about statutory damages upwards of capped at about $150,000, and again, when I say statutory damages, I mean that this is actually written in the Copyright Act, like it's by statute that I'm saying this. If you have damages up like $150,000 per infringement, can you imagine? Like my poor client who allegedly infringed on the photographs. They had about 2 or 3 of them. So you do the math. That's a lot. That's a lot. And you can't turn around and say, well, I didn't know. That's the question that's the response that I get a lot from clients is, I didn't know it was copyrighted, or I didn't know that I was infringing on anyone's copyrights. And my questions to them are very, very simple. Did you create it? No. Did you license it? No. Did you buy it? No. Then you're infringed. I mean, that's just putting it very, very generally, but that's the essence of it. If it's not yours, don't use it unless you buy it or license it. So again, $30,000 is small claims for them. Why? Because these come with very heavy penalties if you're infringing on someone's copyright.
And ignorance is not an excuse for breaking the law. So
no way.
The government doesn't care if you didn't know. You better find out.
Nope. I had another client, just quick other anecdote before we do our wrap up. I had a client who lifted pictures off of Google Images because they were writing a book and they wanted to use pictures of like a celebrity or something like that they were writing about when they met the celebrity and they wanted to put it in their book. I had to tell them, no, unless you physically took that picture, that is not yours. Don't use it. And, we got into the process of trying to figure out who owned the picture because we wanted to go ahead and license it, as well as some other clients that I've had in the past that we've actually found who was in charge of, that there were some famous photographs that they had and we wanted to reproduce it. So we had to find out who was in charge of the person's estate because it was someone who had already passed. So we found a firm that represented the person's estate, try to get a license agreement with them and all that. So that is what's required. You can't just lift photographs off of Google Images and say, I'm putting this in my book and I'm going to sell my book. It doesn't work that way. Unless you physically did it, it's not yours. Unless you bought it, unless you licensed it, unless it's under fair use or public domain, those are the only ways you can use it. So please, let's not get into a small claims $30,000 case just because you're going to say that you didn't know. So
I love Google, but they're the worst when it comes to pictures. The worst. Just don't do it.
I'm telling you. It's because everyone has everything out there. I mean, social media, everything's already out there. It's so easy to lift pictures and it's so easy to do that. But, if you get caught, that's why they're so serious about it. And I really like the fact that the Copyright Office is moving in this direction because it shows the seriousness of it. You can cause a lot of harm to someone. You can cause a lot of harm.
Quick question, Rishma. Let's say I snap a picture of someone a celebrity in a very compromising position, right? And I want to sell that to major tabloids. Can I register that picture before selling it or licensing it to, major tabloids? Or I can't do that since there's someone else in the picture?
No, it's yours.
Okay.
If you took that picture, it's yours. That's why the paparazzi makes so much money. They sell their
Yes,
picture
they do.
to the tabloids. They sell it. Now, the issue with copyrighting it is that once it's copywritten, you then have to now have an assignment to the tabloid. Let's say the Inquirer. I don't even know if that's still around. That's how old I am. But let's say there's the Inquirer.
You're not old.
I feel that sometimes. The Inquirer, most of these places will have like a release form that you would sign that says that you are now releasing all your intellectual property rights in exchange for payment of, whatever the payment is for the photo. But once you've snapped it, it's yours. It's your intellectual property. And that's why you always see all the celebrities come out and all the paparazzi just surrounds them.
Yeah.
They're trying to get the best picture possible so that they can sell it.
Wow.
Yep. It's
Awesome.
tough. So try not to be in any open spaces while you're doing your compromising, whatever. Because you never know who's around. You never know who's around. And of course, everything has its exceptions.
Yeah.
And there was a very famous case with Rihanna and a t-shirt company. I have to refresh my memory on the facts of that. But she ended up winning, which is great. But the general rule is if you didn't make it and it's not yours and you didn't find it on public domain and you're not under one of the exceptions of the copyright laws, then you really have to do the extra work of finding out how you can go about legally doing the thing that you want to do. That's all I have to say. And then with if you're not sure how to do it, I mean, professionals like me are out there. We're the ones who do the hunting to find the other attorneys. We're the ones who are trying to have an agreement with them. We're the ones who negotiate the licensing agreements. So if you feel overwhelmed and you really, really have to do this thing, then hire professionals. I mean, that's what we're here for. Because right. I'm telling you, you don't want the Copyright Office after you. You don't want BMI after you. You don't want ASCAP after you. They are aggressive. They're very aggressive with some of the clients that I've seen in the past where they're just like, this is borderline harassment. I'm like, yeah, because they want to make sure that you pay. Did you use the song? Did you sing it when you're not supposed to? Do you have any rights to it? So, I tend to jump on the bandwagon of the creatives when it comes to that because, it's not fair. I couldn't imagine like spending a lot of time creating something and someone just takes it.
Yeah, it's not nice.
So anyway, so my bottom line is that you work hard for your dream, you work hard on your business, you work hard to create the thing that you created. So do the extra step and protect it. Do the extra step in meeting with professionals that will help you plan what it is that you need to do. And you have to put the work in, even though you're a creative type and you want to focus on the music or the art or whatever. If you plan to have this as your business, do the work because success comes when you're minding your business.
The content on Minding Your Business is for informational and educational purposes only and should not be construed as specific legal advice. This show discusses general legal issues affecting business owners. Opinions of the guests are not necessarily that of the show. If you need assistance with your specific legal issue, please consult with a licensed attorney.